considerations that the court has to look at in making its decision as to whether or not we should proceed on Wednesday, as you indicated, at 10 o'clock. The first one is under Rule 19 of the Arizona Rules of Criminal Procedure. That sets out the rules, and it gives you, the judge, the discretion to order the defendant to go forward, and I believe that you should exercise that discretion. We actually even advised the jury of the order of the proceedings that is contained or set out in Rule 19 of the Arizona Rules of Criminal Procedure. The other thing that should not be lost in this argument about whether or not we should proceed in a star chamber sort of approach to things is the victim's rights. Victims also have a constitutional right to continue. One of the things that I indicated to the Court of Appeals yesterday was that when they were talking about the stay, I opposed the stay and indicated that we should proceed. And the reason that I cited was that the victims have a right to continue with these proceedings. Somehow, their constitutional rights have not been addressed by defense counsel's request. The other thing that we must consider is that we have a jury that's been impaneled, a jury that has been told that they are to serve until the 18th of December. These are all interests that indicate, or these are all factors that must be considered by you in deciding whether or not we should take the defendant's position that they are not going to go forward just because they received a ruling that they did not like. And whether they like it or not, and they're saying it's not a ruling on the merits, it's still an order of the court, of a higher court, that says it is ordered staying the enforcement of the Superior Court's ruling of October 30th, which closed the courtroom to the public. It did not stay these particular proceedings, and what they are in essence asking you to do is to stay these proceedings. They didn't ask you in so many words, but that's what they are asking you to do. I am requesting that you not follow their request and that you not stay the rest of the proceedings in this case. The rules are there for everybody to follow, and it appears that in this particular case, because of a rule that they did not like, they want to hold the process hostage. They are saying, just because we received a ruling that we did not like, we are now going to try to sabotage the process until we can, sometime later on down the road. We know that there were other witnesses that could be called. There's also the witnesses, that witness that was on the witness stand that can be called on Wednesday. There is no reason why we cannot proceed, and I ask you to take a look at or consider Rule 19, victims' rights, the fact that the jury is already impaneled and been told that they were going to be here until December 18th. In light of those things, and in light of the ruling that only talks to the issue of whether or not we're going to close the proceedings, I ask that we proceed, as you indicated, tomorrow, Wednesday, at 10 o'clock. Thank you.
Mr. Nurmi.
Your Honor, one of the things, and I forget the case, but it holds that the state is presumed to know the law. Then the state would be presumed under that case, which I cannot cite for the court, that I believe it's under Romley, the Superior Court, that when the rights, victims' rights conflict with those of the defendant's rights are superior. This is not, as counsel for the state says, what he makes is a very pedestrian and non-legal argument that we got a ruling we didn't like, so we want to hold the process hostage. We're going to sabotage the process. Again, we advocated against this stay. We would prefer to go forward in the manner that in which we were proceeding before this stay was granted. But that has not happened here. So ultimately, those rights, that heightened sense of due process that Ms. Arias is entitled to, is of much more significance. Rule 19 is a non sequitur. It doesn't apply in this situation. The proceedings will go as they go, and in conjunction with Rule 19, but at the same time, they have to be done in a way that's cognizant of the rights due Ms. Arias. And that's where the problem is. And this court in and of itself said that it would be problematic for the defense to go forward. I see nothing that has been put before the court to reconsider that ruling, that it's problematic. This is different than the Court of Appeals staying it. The court is determined based on the evidence presented to it that it's problematic for the defense to proceed forward. I think, as we said before, that problematic nature is of constitutional significance, which would make any death sentence imposed, granted, or any verdict, be one that could never be imposed upon Ms. Arias. She has the right to litigate these issues. It's not a matter of holding these proceedings hostage. We want to go forward. If the court wanted to go forward tomorrow under the procedure we were going forward with, we would do it gladly. But that's not the situation we're under. That's what the media interest thrust upon us. That's what we must deal with. And Ms. Arias should not be held to suffer because of what the media has done. If the media causes a mistrial, if we have a mistrial by media, so be it. And the state never opposed any of the media motions. They wanted them in here so they could exploit these proceedings just as much as the media. So, Your Honor, we believe that we have the right to go forward, litigate the issue on its merits, and when it's done, and then we can move forward.
All right, this court denied the motion for stay on Friday. The Court of Appeals denied the motion to stay the proceedings. They granted the motion that would stay this court from allowing the witness on the stand to testify in a sealed proceeding. So, as I read the order, at this point, the defense must decide if they wish this witness to continue not in a sealed proceeding, or if you want to take another witness out of order. I realize that it may be problematic and it may not be your preferred manner of presentation, but I have the list of defense witnesses in front of me, and I think there are a number of these witnesses that there would not be an issue calling out of order. I understand that you do have a deadline for Friday to file your documentation, and so I am willing to limit the amount of time you need to be here for trial this week. We did ask the jury to come back tomorrow at 10 o'clock. Let me ask the defense, as it stands right now, when do you expect this case to conclude? We told the jury December 18th. Do you believe that's still realistic?
Your Honor, to the court's recollection, we never took the position that that was realistic when they set the date. We believe that it should have been through the end of January. So
that's still your position?
Yes, at least.
Mr. Martinez.
Knowing what I know about the witnesses and what they may or may not testify to and what has happened that you are aware of, I do not agree that January was or is a realistic end date. I think that the date of December 18th is realistic still. In light of the witnesses, there's the two experts, there's the potential of another witness from California, and then beyond that, there's just affidavits as I understand it.
Your Honor, the other thing we'd be asking to make record of today is the court seems to be changing its position, and I don't know what legal basis the court is using for deciding why we should be forced to go forward under these circumstances, because we already have the problematic nature. It seems unconstitutional under all prevailing death penalty jurisprudence, yet this court seems to be reversing its position. I'm asking for the basis of that.
I understand the need for certain witnesses to testify before other witnesses in the case. I do understand that, but I believe in looking at the list of witnesses provided to the jury and provided to the court that there are some of these witnesses that could be taken out of the preferred order without doing any harm to the defense case. I don't want to say anything more in a public proceeding because of the sealed nature, and all of the records are still sealed by the Court of Appeal, so I don't want to discuss anything too specifically about that on the record in open court. Let's have a conference at the bench briefly on the actual witnesses. It will be called.
I have to edit the tease. I have to edit the tease. It's like a tease with some video.
Everyone will reconvene tomorrow morning. All right, the court has conferred with counsel at the bench. Everyone will reconvene tomorrow morning, 10 o'clock. There will be no witnesses this week. The court is dark on Monday and Tuesday of next week, so the witnesses will begin testifying again on Wednesday at 9:30, Wednesday of next week. All right, anything else for today?
I don't have anything.
Nothing, Your Honor.
Thank you.